an appeal in the matter of CP and Secretary of State for the Law Department.
Yes.
Lords, Milady, I'm here for the Secretary of State this morning, who is the appellant in these proceedings. My learned friends, Mr. Kiriko KC and Mr. Lewis, appear for the respondent, CP. Just by way of housekeeping, my Lords, Milady, there is a supplementary bundle from my learned friends and a short note. Just checking if that has...
That's supplementary authorities, is it?
Yes, supplementary authorities.
We've got that on the desk, but we haven't seen it before.
Great.
And the note.
Sorry?
And the note.
And the note, indeed.
Yes, it's right that we hadn't, until this morning, seen either your supplementary skeleton argument or the recent response to it. So we've only had a fairly brief opportunity to look at that.
So, my Lords, Milady, CP, as the court knows, is a Jamaican national who has been residing in the UK unlawfully. Not only does he have no leave to remain, but his presence in the UK also constitute a danger to the community. This is because he has been convicted of 2 counts of rape, for which he received an extended sentence of 14 years imprisonment. He committed those offences while he was already facing deportation proceedings for his earlier offending. His previous convictions, for which he received a sentence of 4 years and 8 months in imprisonment, included unlawful wounding, attempted burglary, and burglary. Among other things, he had stabbed his former partner with a knife. On the evidence, he poses a substantial risk of violence and aggression, in particular against women. CP, my Lords, Milady, is an asylum seeker. The offences that he has committed are so serious that he is excluded from the protection of the Refugee Convention. The Secretary of State seeks to deport him from the UK, and CP's case is that his return to Jamaica would be incompatible with his rights under Article 3 of the ECHR. Approximately 30 years ago, CP's mother witnessed a murder in Jamaica and gave evidence at the trial, which led to the conviction of a gang leader. In 1997, she entered the Witness Protection Program in Jamaica with CP as her child, and she relocated to the UK in 1999. CP says that if returned to Jamaica, he would be at risk from the gang because of those events, and the Jamaican authorities would be unwilling or unable to provide him with effective protection. A judge of the First-tier Tribunal dismissed CP's appeal. On appeal, a panel of 2 Upper Tribunal judges set aside that decision and substituted a fresh decision allowing the appeal on Article 3 grounds. And, my Lords, Milady, this is the Secretary of State's appeal from that decision. There are, as the court knows, 2 grounds of appeal. The first ground is that the Upper Tribunal impermissibly rewrote the country guidance and erred in departing from it. The First-tier Tribunal had made no error of law in dismissing CP's appeal, and the Upper Tribunal should not have reversed it. The second ground is...
Did they really rewrite the country guidance, Mr. Malik? Didn't they simply clarify what the law is to be applied to the facts of the country guidance? They didn't change the facts of the country guidance.
No, well, it really depends on what country guidance actually entails, my Lord. I understand.
And so far as the law, the relevant law is concerned, surely whatever may or may not have been open to the Upper Tribunal, it's open to this court to say, well, the Upper Tribunal in AB misstated the law slightly, and the correct statement of the law is as follows.
So,
We can do that, can't we?
absolutely.
So I mean, this in a sense is I'm not being rude, shadow boxing, if you understand the expression.
Lord,
What matters is what's the correct law?
Absolutely. So, my Lord, I mean, this court obviously will say what the correct law is, and whatever this court says will be binding. One issue that Ground One raises is this, that if the upper tribunal takes the view that a country guidance decision is wrong, then what is it that it should do? The reason why the point is made is because it is an important point that is of some significance. If the upper tribunal takes the view that the law stated in a country guidance case is wrong, and you'll hear more submissions on this when I develop the point in due course, it should constitute a fresh country guidance panel to essentially correct the error that it considers was made in the earlier case. But for practical purposes, my Lord is absolutely right with respect that the real sort of question of practical significance is what the law is. The second ground is that in substituting the fresh decision, the upper tribunal misdirected itself as to the country guidance and failed to engage with material issues and relevant evidence. Subject to any observations, what I propose to do this morning is to take you to key documents and decisions relating to facts in a chronological order for context, and I will then address you on the two grounds in turn and the upper tribunal's analysis. So documents first and facts. My Lords and Lady, if you have the supplementary bundle, at page 1, you will find the notice issued by the Secretary of State following CP's earlier convictions in 2009. By this letter, the Secretary of State noted that CP had committed serious crimes, had received a sentence of 4 years and 8 months in custody, and notified CP of her intention to deport him. Essentially invited CP to make any submissions if CP considers that he falls within one of the exceptions. While the Secretary of State was considering making that deportation decision, as the court knows, CP committed further offences. And page 6 of the supplementary bundle, you have the 2013 sentencing remarks. If you look at page 7, this is where the sentencing judge summarizes the facts. And if you look just above letter F, you'll see that what CP did was, in his view, a form of punishment or revenge against the victim. Either because what she had done in the flat earlier on, or because of her rejecting any advances by CP. There is then an account of what happened during the offending. If you look at the next page, page 8, between letters C and D, you will see the sentencing judge summarizing the previous offending. And my lords and lady will see that CP previously, this is the 2009 conviction for which he was sentenced to over 4 years imprisonment, stabbed the former partner in her back with a knife. And you'll see that the evidence, the judge said, made extremely disturbing reading. This is between D and E. And the conclusion that the judge reached is that CP has a history of violence and aggression, particularly towards women. And it was perfectly clear, the judge said, that he posed a substantial risk of violence, anger, aggression towards others, in particular women, into whose company he come. He's obviously a dangerous criminal, and he was sentenced to 14 years imprisonment. That is the extended sentence. Now that sentence was not disturbed by this court on appeal. Just for the purposes of your note, page 11 onwards is the judgment of the criminal division of this court, where you'll see the background facts at paragraphs 5 to 17. So this is the sentence for the offence of rape.
Appeal against both conviction and sentence. Is it? I think it must have been.
Yes, that is correct.
Paragraph 44.
Yes.
Counsel was saying that the judge shouldn't have admitted the evidence of the previous conviction.
Yes. So this was an appeal against the conviction and the sentence. The judgment, of course, records the devastating impact on both victims, the victim of rape and the former partner who was stabbed with a knife. Now, following this sentence, for obvious reasons, the Secretary of State made the deportation decision.
He served the custodial element. Is that right?
He
Yes.
has, yes, it seems.
And the extended license has almost run out, but not quite.
It was released in mid-2022, I think.
That must be right, yes.
So he'd served, he'd served 9 years.
My lords, my lady, he's been recalled, so he's in custody at the moment.
Well, I know he's been recalled, but he'd
Yes.
served the sentence, I think somewhere it says mid-22, I'm not sure we're going to
Yes.
decide.
Yeah.
And he was then recalled because there's obviously been a breach of the licence conditions. So we don't know. But he's currently in custody. He's in prison.
Yes.
So following this, the Secretary of State made the deportation decision. You have that decision at page 24 of the bundle, the supplementary bundle. So the Secretary of State says that essentially automatic deportation provisions apply, and the Secretary of State is seeking to deport this person. There is, of course, no right of appeal against the deportation decision. The right of appeal is against the refusal of the asylum and human rights. Not only that, if you look at page 33 of the bundle, the Secretary of State issued a Section 72 certificate that essentially regards the fact that CP is excluded from the protection of the Refugee Convention because his presence constitutes a danger to the community. That is for the reasons of his offending. As the court knows, CP makes a protection claim and a human rights claim. The Secretary of State considers those claims and refuse them in a decision that you have in the core bundle at page 89. So if you look at that decision, page 89, you will see a heading, reasons for the decision. And under that heading, the uncontroversial immigration history is set out. And my lords and my lady will see that CP's leave to remain ended on 15th of September 2002. He should have left the country before the expiry of his leave. He resided here unlawfully. His various applications are refused. Still at page 89, second last paragraph. In 2004, a removal decision was issued in respect of him, a notice that he is liable to removal. He then makes an asylum claim, and you'll then see what happened thereafter, essentially convictions, considerations of various submissions, etc. Page 91, you'll see a heading, section 72 of the 2002 Act. So under that heading, the Secretary of State refers to the sentencing remarks to which I've taken you to, emphasized certain parts and decided that he was excluded from the protection. Page 93 are the detailed reasons for refusal of the Article 3 claim. And you will see a summary of the claim made by CP at page 93. And there is then a detailed consideration of that claim. Page 95, this is the paragraph that will become some relevance in relation to ground 2. Page 95, if you look at the fourth paragraph, you will see that the Secretary of State made a point that his case was that the person who went to prison could have been released. The Secretary of State says that CP and his family in Jamaica and in the UK have remained unharmed for some 22 years, now around 30 years. And the basic point is that, well, the person who went to prison has already spent time there. Why would he seek to target CP? In the circumstances when CP had no direct involvement with him, second last sentence. What happened in 1997, CP was 11 years old. He had no direct involvement. So why would the person in question seek to target him? Bearing that in mind, if you look at page 96, you'll see a heading, summary of findings of fact. And you will see that the Secretary of State rejects the claim that he would be at risk because of his mother's actions. So the primary point made by the Secretary of State is not about sufficiency of protection or internal relocation. The primary point made by the Secretary of State is that, well, this all happened many, many years ago, and CP would not be targeted by that particular criminal, essentially because he had no involvement, no direct involvement with him. The Secretary of State could have ended her decision there, but she then made two alternative points. The first point is about sufficiency of protection, just at the end of page 96. And the discussion goes to page 97, you will see a reference to Howarth. I'll take you to that judgment in due course. And the Secretary of State makes the point that no state can achieve complete protection against isolated and random attacks. The standard is not which eliminates all risks amounting to a guarantee of protection. Rather, it's a practical standard which takes into account duty of the state, duty a state owes to its nationals. The Secretary of State then applies the country guidance in AB. Of course, you'll hear more about this in due course when I'll take you to AB. So I'll simply skip over those paragraphs for the time being. But if you look right at the end of page 97, last paragraph, so apart from relying on apart from relying on AB, the Secretary of State then considers evidence that postdates AB. Improvements that have been made in Jamaica. So last paragraph, page 97, you will see a reference to a 2016 USSD report relating to the Witness Protection Program. On the next page, page 98, you will see a 2014 statement made by a mayor. And the conclusion of all that, the conclusion of the analysis in AB and the updated objective evidence is in the fourth paragraph at page 98. Second sentence, as the background country evidence sets out above demonstrates, that includes AB and other objective country evidence, avenues of redress are available to you, and you are able to utilize them based on the country information cited above. It is believed that the authorities in Jamaica are able to provide you with effective protection to the standards set out in Howarth. The second alternative point concerns internal relocation at the end of page 98. The Secretary of State records, this is the last paragraph at page 98, that CP says that he has an affair in Kingston and Westmoreland. That, the Secretary of State said, meant that it was possible for him to relocate to a different city, a town or village of Jamaica. The Secretary of State again considers the country guidance in AB as to that question. And paragraph 5 at page 99 is the conclusion. You have not shown that it would be unreasonable to expect you to live in another area of Jamaica. So what one gets from this decision is that the Secretary of State essentially made three distinct points. First, that he wouldn't be targeted. Second, there would be sufficiency of protection. And third, internal relocation. And the Secretary of State relied on objective evidence. Now, may I then take you to the Secretary of State's skeleton argument that was before the First-tier Tribunal, just to show you how the case was put. That skeleton argument is in the supplementary bundle at page 49. The process, as the court knows, Milady Lead Justice Elisabeth Laing has dealt with that in a judgment called AL. The appellant files the skeleton argument and evidence. The Secretary of State then conducts a review of that evidence and files a document identifying the issue. So this is the Secretary of State's skeleton argument. If you look at paragraph 9 you will see that the Secretary of State identified the two issues. The second issue is whether there would be a risk of serious harm in Jamaica. You'll then see various submissions that are made. And if you look at page 53, paragraphs 18 onwards, in broad sense, in short, the Secretary of State sort of made the point that is made in the decision letter about the passage of time and there being no ongoing interest. Secondly, if you look at paragraph 23 of this document, you will see that the Secretary of State placed reliance on evidence that postdates AB. The legislation passed in 2014, the anti-gang law. Paragraph 24, the Secretary of State relies on a CPIN document. I'll take you to that document. It refers to objective evidence and makes a submission that there is sufficiency of protection in Jamaica. Just bringing things to a closure, paragraph 26, Secretary of State's primary position is that due to passage of time and lack of effective and real causation, CB does not in any way require protection by means of the WPP in Jamaica. The first point is that there's no risk. It's all quite old. Protection by the witness protection program is not needed. The alternative submission, this is still paragraph 96.
Pause a moment. Can you just remind me when the cousin was killed?
My apologies, I do not have that date to hand, but
Can you
I
help
I think
Mr.
it's
Chirka?
2010.
2010, thank you.
2010.
So that is the primary point the Secretary of State makes. Whether it's a good point or a bad point is a different matter. The alternative point is that CB would be able to access effective protection. And the final point, which is made expressly in the decision letter, is made again at paragraph 27, that internal relocation is a viable option. This person has considered robustness, adaptability, ability to secure employment, and he can reside in a different area of Jamaica if he wishes to do so. So all 3 points were made to the First-tier Tribunal. Now, the CPIN document that is referred in this skeleton is in the authorities bundle behind tab 4. So this is the Secretary of State's country policy and information note. In essence, this is a body of objective evidence by reference to which decisions are taken by the Secretary of State and by judges as to country conditions.
I'm so sorry. Could you just give me the reference again?
So it's tab 4 of the authorities bundle. tab 4, this is page 24. And this is the evidence that was before the tribunals. Now, if you go to page 31, you'll see heading risk. Paragraph 2.4.1, in general, a person who is not involved in or connected to a gang-related activity, this is sort of gang-related activity in Jamaica, will not be at real risk of serious harm or persecution from an OCG. However, if a person is able to establish that they are of interest to an OCG because of their personal circumstances, the decision makers must consider OCG's intent, capability, reach, as such are such that there is a real risk of serious harm or persecution. So the point that the Secretary of State was seeking to make in the decision in the skeleton is that CP is not of interest to a criminal gang. And the Secretary of State was making a point about the person who was convicted in Jamaica as to his intent, capability, and reach. If you then look at paragraph 2.5, you'll see a heading, protection. Under that heading, you'll see that CPIN refers to the country guidance in AB and quotes what the country guidance is. Of course, you'll hear more about this shortly, but the country guidance in short is that Jamaica, the authorities in Jamaica are in general willing and able to provide effective protection.
Which paragraph is that?
This is page 32, paragraph 2.5.1.
It just sets out the head note.
Head note, yes. So this is the actual country guidance. And of course, the question here is whether the words "unless reasonably likely to be admitted" are in error, and that really is the first ground. If you look at the next page, page 33, I'll skip over this now because I will address you on AB separately. Paragraph 2.5.3, this is where the Secretary of State notes that, well, since AB, the government has introduced a number of legislative and policy measures to strengthen the rule of law and combat general OCG-specific crime. You'll see a reference to the 2014 legislation. And then 2.5.4, the government has taken reasonable steps to establish an effective criminal justice system that is able to detect, prosecute, and punish criminal actors. But there are issues with effectiveness, and there are weaknesses. On the next page, there is again various references to post-AB steps taken by the legislature and the government in Jamaica.
I'm just reading to the end of 2.5.4.
Yes.
On the available country evidence, there are not strong grounds supported by cogent evidence to depart from the findings in AB. So does that represent the Secretary of State's view that from a factual point of view,
Yes.
AB still represents the position that this is in 2024?
Indeed. We'll then see further references to objective evidence on the next page, including at paragraph 2.5.10, that there is a functioning judiciary which is generally considered to be independent, but there are issues. So this is sufficiency of protection. If you go to page 35, you'll see a separate heading, internal relocation. And again, you see that the CPIN document adopts what was said in AV, that evidence does not support that internal relocation is unsafe or unreasonable option in general. And then 2.6.
It's the same
2.6.
point in 2.6.3, isn't it, where
Yeah.
they get to.
Yeah.
It's saying there are not very strong grounds supported by cogent evidence to justify a departure from the country guidance.
Indeed, and the country guidance essentially is that in general, internal relocation is not unsafe or unreasonable. And what is quoted at 2.6.2 is that unless a case is a high-profile case, then a person who faces risk from a gang in Kingston or other inner city urban area is able to relocate elsewhere. So this is the CPIN document that was before the judge. Just one final document, and I'll then take you to the First-tier Tribunal's decision. That is a letter from Jamaican authorities, which CP seeks to rely on, and that document is in the supplementary bundle at page 64. So, my lords, my lady will see that the Secretary of State sent a correspondence to the Ministry of National Security in Jamaica with certain questions. It is, of course, crystal clear from this correspondence that Jamaica does not want this person to return for obvious reasons. But if you look at the question that is asked, the question was, please could you advise whether a relevant person such as CP could, not that he would, but could be accepted back into the witness protection program? The answer could have been yes or no, but you'll see that the response is that there is a high probability of harm against family in Jamaica, and there's also
That's of some significance, isn't it, in the light of what you've shown us previously? Because this is the Jamaican authorities less than 3 years ago saying the probability of harm to the family, which must include CP, is high, capital letters.
Yeah, indeed.
And the fact that it's in answer to a request about CP
Yes.
makes reasonably clear that by family they're including him.
I don't dispute that. Of course, I understand that is the response. But the
have to
question,
take it at face value, don't we? I mean, we
Yeah,
have to
yes, you-
take it at face value.
indeed, you-
Assessment of the Jamaican ministry.
indeed, you of course, I mean, you accept this evidence. So no,
Specific to this family, including CP.
yeah. So no one disputes.
Those are general statements by the British government in the documents they produced
No,
about
so,
what might or might not be the position generally.
so no one disputes that. But the question, my lord, my ladies, was whether he could be admitted to a witness protection program. The question that, for the reasons I will come to, is the relevant question. So there is a high probability of harm. The court, of course, will proceed on that basis. But that is if, and I understand this to be common ground, if this person is not admitted into a witness protection program. Then you'll see the last sentence under that paragraph. There is no guarantee that he will be placed on the witness protection program if he returns, as there are various assessments that will be likely to be done before such determination can be made. So the answer to the question that is asked is yes, that he could be admitted to the witness protection program, but there is no guarantee that he would be. That is the point that is relevant for the purposes of the argument that I will make. If he enters the witness protection program, so the answer is that
Those references to the assessments by state agencies, they would include assessment of the factors that are set out in the Jamaican statute. I think
Yes,
the 2014 statute.
yes, so that is a matter, of course, for
Including his criminal record and his
Yes.
mental health issues.
yeah. So that, of course, is a matter for Jamaican authorities.
Presumably why they make why they say there's also the likelihood of psychological trauma.
Yes, so if he is not entered into witness protection program, then the evidence is that there is a high probability of harm. He could be entered into witness protection program, but there is no guarantee. It would all depend on the assessments. And then if you look at page 65, you'll see that accepting in the program is based on the assessments as outlined above. So all will depend on the assessments. There's no change in the procedure, etc. So that's that. Now you then go to the first-tier tribunal's decision, which you have at page 77 of the core bundle. Both sides, as you'll see, are represented. Paragraph 8, CP concedes that he is excluded from the protection because of the certificate, decides not to pursue an Article 8 appeal. And the point is simply about Article 3. The judge at paragraph 18 considers the correspondence that I've just shown you, quotes that correspondence in full. And then makes a finding of fact at paragraph 19 that the appellant has taken no steps to seek readmission to the witness protection program in Jamaica. No steps that he took to seek admission. So no attempt essentially to seek protection of the domestic authorities. You'll then see a discussion as to law.
Well, he also refers to an expert report from Mr. Sobers.
Yeah.
Who seems to pop up in all these cases. Who says that his opinion was the appellant would not qualify for witness protection.
Yeah. That is of course
I haven't seen the letter, but that was his opinion.
Yeah, that was indeed his opinion. You then see heading law, under which the judge discusses the question of burden and standard of proof by reference to various examples and a diagram. And the conclusion that the judge reached on the relevant question is at paragraph 30. My conclusion, the judge says, is that the respondent's position is correct. You'll hear more about this from me, but the only question is whether it is reasonably likely that the appellant would be admitted on to witness protection program. This is what AB said, and the judge referred to Howeth. The judge notes at paragraph 32 that CP in effect argues that a real risk must be eliminated for sufficiency of protection to apply, and the judge says that that would be wrong. And I will explain why the judge was right and why that position is wrong. But can I just very quickly show you certain other findings of fact that this judge made? So if you go to page 83, So the letter, the correspondence, my lord, my lady, that I've shown you from Jamaican authorities was a piece of evidence. It was for the judge to consider that evidence together with all other evidence and make findings about it. And the upper tribunal can only intervene if there is an error of law. At paragraph 35, the judge considers that correspondence and says that the Jamaican authorities have made their position clear, that there is no guarantee that the appellant will be placed on the justice protection program if he returns.
So sorry, where are you reading from now?
This is paragraph 35. Paragraph 35, fifth line.
Well, he makes a perfectly valid point. If the reality was that there was simply no possibility, the Jamaican authorities would have said so.
Yeah. So there is.
So that he's simply making the point. They say there's no guarantee, and that must be right.
Yeah. So that indeed. So that means that there is a real possibility.
There's a possibility.
And that's, as far as the First-tier Tribunal was concerned, was the right test.
That was
Whether
the
there's
right
a real possibility, and
Yeah.
there was a real possibility of him being in the programme.
Indeed. And then if you, so that is the first point the judge makes. You will then see this is the fourth last line. Furthermore, so this is an additional point the judge makes. I find it to be clear that Jamaican authorities are respecting and accepting the duty they owe to the appellant as their citizens. They are in a considerably better position than this tribunal to assess the threat to him in Jamaica and deal with it accordingly. So essentially it is for the Jamaican authorities to take a view as to whether there is a threat. And if there is a threat, how to deal with it, how serious the threat is. And they are in a better position to make that assessment as compared to the tribunal. Paragraph 36, last two sentences, the judge considers all other matters, previous decisions. It says that an inability to offer protection would not be consistent with the country guidance. Overall, I do not accept that Jamaican authorities could not protect the appellant. Well, could not protect the appellant. The judge then makes a point about a possible abuse of Article 3 if CP were to succeed in the argument that CP pursues. And that is the point that is made at paragraph 37. That CP has a strong incentive not to seek assistance from Jamaican Witness Protection Program while he's in the UK. This is because if he seeks that protection, and if it is offered, then his appeal would become hopeless.
How far do you take that point? Depending on what the test is. Suppose you're wrong on ground one, and the test is whether there's a real risk or a reasonable likelihood of him not being on the programme, which the tribunal assesses in accordance with the evidence it has, such evidence as it has from the Jamaican Ministry and Mr. Sober's report. If on the evidence the tribunal has, that test is fulfilled, do you say, well, that's not good enough, because actually you've got to test it. It would be an abuse not to have tested it and to say I'm just relying on the evidence. Is that where your submission goes?
No, the submission is, of course, this court will identify what the test is.
Yeah.
But in deciding what the test is, the court, in my submission, should be mindful of the consequences of the submission that is made on behalf of CP.
Well, the difficulty with that submission is that if we decide what the test is, well, the consequences must follow. So, I mean, paragraph 37, I understand why the judge put it in there, but it's really just prejudicial points, which, if he's wrong on the law, don't actually take matters further. And there's no sort of proviso to all of this that says, well, if in fact you form the subjective view that he's abusing the system because he hasn't asked for protection from the Jamaican authorities, then he loses. And that's just not the law.
Well, Lord, this is a point that is, in my submission, of real significance and real substance. Of course, the court will consider whether that submission is made out or should be rejected. But if the Upper Tribunal is right, and if my learned friends are right, then the Secretary of State would find herself in an impossible, if not in quite difficult, if not impossible position. A person from Jamaica who is in the UK says that he is at risk from a criminal gang. He would take no step to contact Jamaican authorities. He would seek no assistance from the Witness Protection Program, because to do so would undermine his appeal. The Secretary of State cannot force...
Might or might not. And the Secretary of State can make inquiries of the authorities in Jamaica and did so in this case.
That assumes that you, as it were, you move beyond the if you assume that the right test, as my Lord says, is there's a real risk or reasonable likelihood of it not being put on the programme, that's a forward-looking test. It's not dependent on whether you've actually asked the question. Because you ask the question and the answer is, no, you can't come on the programme, then that test is completely irrelevant because you've got an answer. You can't be on the programme, full stop. And then true it is that if the answer to the question is, yes, you can be on the programme, then his appeal fails. You're absolutely right about that. But on that, equally, if you ask the question and the answer is no, well, all of this analysis as to what the right test is in AB is neither here nor there.
Yeah.
But isn't the Secretary of State in just as good a position to test the evidence? There's a report from Mr. Sobers. The Secretary of State can say, well, this is what the Jamaican authorities have said. We've asked them. They've said it's subject to the statutory assessments. Here's our report from an expert we've commissioned, which says actually his criminal background, his mental health difficulties wouldn't preclude him from being taken on the programme, and there's no real risk of that happening. But the fact that he has not applied doesn't really prejudice the Secretary of State, does it?
Well, Lord, as the judge said in that paragraph, what this person is doing is not seeking the truth, but essentially trying to find a way to avoid deportation. Now, what the Secretary, Lord, just to answer your point, what the Secretary of State can do, as you rightly observed, is to ask the Jamaican authorities as to what could happen. The response from the Jamaican authority, one would imagine, would not be very different.
Because I understand the point you're making. I haven't seen Mr. Sobers' report. Do the assessments that the Jamaican authorities are talking about include face-to-face assessments, for example, in relation to mental health? Would he have to go to Jamaica in order to make the application? That's what I'm asking.
Well, I don't have the answer to that question now, but I will.
Well, that's quite an important question, isn't it? Because it may not be reasonable to expect him to go to Jamaica.
Indeed. And
in order to find out whether he's going to be put in the witness protection program, when going to Jamaica may expose him to the risks that we're concerned with.
So the point...
Isn't that critical to whether this point about abuse is a good one or not, even taken at its highest?
The reason why you don't have expert evidence before you, of course, is because this isn't an appeal on facts. The finding is that he has not sought assistance from the Witness Protection Program.
I understand that. And the point that the First-tier Tribunal judges are making is that's an abuse. He oughtn't to be allowed to run the case without actually making his application. But if making his application involves him going to Jamaica in order to have to make it, then, speaking for myself, I find that would completely undermine this suggestion. And I'm just asking what the factual position is on that and whether there was any evidence about it.
Okay. Lord, I will find an answer to that question.
May I sorry to interrupt, Mr. Mack. May I ask a further question, please? Is it your submission that the point made in paragraph 37 of the First-tier Tribunal's determination is a complete answer to the appeal, or not? I just want to understand what your submission is. Does that reasoning enable the First-tier Tribunal to sidestep the question about whether or not, if you were to apply, the risk that he couldn't get protection?
This is an answer to the appeal.
Well,
You say it is an answer to the appeal.
It is the answer to the appeal, yes.
Well, that then brings us back to precisely the point that my lord asked.
Yeah.
Because if the reality is, in order to make an application,
You'll have to go to Jamaica.
in country,
So, Lord,
plead defeats the object of all of this.
yes. So, Lord, I will find an answer to the question that you asked. But may I, for the purpose of the argument, assume that that is the case, that one has to go to Jamaica to apply for protection.
Right.
And my lord says that if that is the case, then, well, paragraph 37 is sort of significantly undermined. I don't believe that that would be the case, but assume that that is the case. That still has equal force, because a person then goes to Jamaica, and it is for the Jamaican authorities to decide what steps to take to protect a citizen of Jamaica from the risk. So if they have a functional system, and a person has to go through various assessments, then in my submission, the fact finder would proceed on the basis that there is a system in place and the authorities are able and willing to provide.
Right? Doesn't the country guidance say, but for the witness protection program, the risk arises? This is a test as to whether you get into the witness protection plan in the first place.
Yeah.
There's
Right.
no suggestion that there's sufficient protection whilst you've applied, and I don't think that the country guidance lends any support to that, does it?
So, Lord, can I
Tell me if I'm wrong. Is that right or wrong?
No, no, Lord, the submission that I have just made, I do respectfully maintain that submission, but may I show you one authority and then AB to explain why I make that submission?
Okay.
Yes.
Firstly, the judgment in Haworth, it's tab 6 of the bundle. So this is the ultimate authority on the concept of sufficiency of protection. What are the duties of a state in the context of a protection claim? And you'll see from the head note that the appellant, the applicant in that case, claimed asylum on the basis that there was a risk of persecution by sort of non-state actors. And that was the context in which the asylum claim was considered and the appeal reached the court. The judgment of Lord Hope is at page 186.
Yeah.
And if you go to page 187, and if you look at letter E, the text against letter E, you'll see the text of Article 1A of the Refugee Convention. And you'll see the words that are used: unable or unwilling to avail himself of the protection of that country. The significance of those words was then subject of detailed analysis. And if you go to page 192, you will see a summary of all that analysis right at the end. To sum up, therefore, on this issue, says, I consider that the obligation to afford refugee status arises only if the person's own state is unable or unwilling to discharge its own duty to protect its own nationals. So in this context, if Jamaica is unable or unwilling to discharge the duty to protect CP arises, then there could be a case that the return would be incompatible with Article 3. And then if you go to next page, page 193, against letter F, the primary duty to provide protection.
Sorry, which letter?
Letter F, my lord, at the end. So this, in my submission, goes to the question that was asked. The primary duty to provide protection lies with the home state. It's not the UK that is primarily responsible for protecting CP from criminal gangs. CP is not a national of UK, it's a national of Jamaica, and it is for Jamaica to protect him, not for the UK. It is its duty, the duty of the state, to establish and operate a system of protection against persecution of its own nationals. If the system is lacking the protection of the international community is available as a substitute. The primary responsibility is with Jamaican authorities. The UK's responsibility, if any, is in substitute. But then Lord Hope makes an important point. Now, that the substitute cannot achieve complete protection against isolated and random attacks. So the complete protection against such attacks is not to be expected of the home state. So the point, my lords, is that if CP is facing a risk from a criminal gang here in the UK, in London, then the authorities, the British authorities, cannot provide absolute immunity against random attacks. If someone is at risk here in the UK, he cannot say that, the state provides me a protection that is such that there remains no real risk that I will be I will not be targeted. And Lord Hope is saying that
it's common ground, isn't it? I mean, I think it is common ground. If CP were admitted into the witness protection program, he would receive effective protection in Jamaica.
All the standard protection, even if not a guarantee.
Even
not a guarantee.
100%, but sufficient protection.
Yeah.
Which is the point. That's the only point that Lord Hope's making. It's not 100% protection, but it's whatever it is. It's enough, sufficient.
The point that my submission, Lord Hope, is really making in that paragraph is just to apply the reasoning in this context, that it is the responsibility of Jamaican authorities to protect a Jamaican national.
Yes.
Not the responsibility of the UK. So if there is a
disputes that, the question we have to grapple with is not to do with sufficiency of protection within the witness protection program, but what is the correct test for when you get into the program or not?
There is, in my respective submission, a sort of prior question. The prior question being that, and this essentially goes to the question that my lord put to me, that, well, if he has to go to Jamaica to make an application to get into witness protection program, then it's not good enough. The answer to that submission, the answer to that observation in my submission is in this paragraph. If Jamaica has a functional system, there is a functional witness protection program. There is a functional system of assessments, etc. It's perfectly legitimate in my submission for the United Kingdom to return a person who is at risk to Jamaica, for Jamaican authorities to deal with him. They will go through their own process, various assessments. If they take the view that there is a risk, they will place him in the witness protection program. If they take the view that there isn't a risk, then they will not.
Or if they take a view that there is a risk, but he's a criminal, he's got mental health difficulties, he doesn't meet the statutory criteria,
Then he will not.
then they won't put him in the programme. But
So
the point we were on in relation to paragraph 37 is, what about what happens in the meantime?
yes,
Well,
but
two things: what happens in the meantime, and what happens if he's not admitted into the programme. In relation to which the Jamaican authorities have said that the risk of harm to his family is high.
yeah, so the risk
So
of
they clearly, I mean, they don't specifically address relocation within Jamaica. But there's quite a lot of evidence about that in the country guidance. And it's not that big an island.
about relocation, of course, that is a different question. I'll address you on that. But here I do respectfully make the submission that, I mean, it cannot be the case that unless a Jamaican national in the UK is admitted while he is in the UK in the witness protection program, the return would be incompatible with Article 3.
No, I don't think anybody's suggesting that. Someone's got to look at the degree of risk, probability, whatever the right test may be, about whether they will or will not be admitted. I think that's common ground.
So your submission is that if, and we don't know whether this is the case or not, he would have to return to Jamaica in order to undergo some kind of assessment. We can assume on the basis of Horvath that will be adequately protected by the Jamaican state while he's undergoing that process. That's your submission.
That is the submission.
Right. But that doesn't deal with what happens next, which is the risk that he might not get into the program ultimately. Yeah.
So
okay.
I take that. So well, that is the submission, and that submission can be rejected or accepted by a fact finder if the fact finder takes the view that there is a systematic issue in Jamaica. Then that is different. But can I just also draw your attention to what appears right at the end of page 193 against Red Hatch? The point being that, well, this is an imperfect world, and certain levels of ill treatment may still occur, even if steps to prevent this are taken by the state to which we look for our protection. So yes, if he goes to Jamaica, to give the example that, to take the example of Lord, there is of course a risk that he would not be admitted onto the program, and the state would fail in protecting this particular person despite taking every step. But that is inherent, Lord Hope says in my submission, in every system. And if one elevates that to a standard that essentially prevents deportation or removal of a person unless that person is admitted, then that creates serious difficulties. Finally, if you go to page 203, may I ask you to look at the text that appears between letters F and H.
Sorry, Sam.
Page 203. We are still in Howard. The use of words like sufficiency and effectiveness does not provide a precise solution. Certainly, one would not be entitled to absolute guaranteed immunity. That would be beyond any realistic practical expectation. And just text against letter H. This really is is the high-level test. Well, there must be in place a system of domestic protection and machinery for the detection, prosecution, and punishment of acting contrary to the purposes of the convention. More importantly, there must be an ability and readiness to operate that machinery. So if, for example, the response from Jamaica would have been that, well, we are not even going to look at this case, the position is different, but the evidence demonstrates, in my submission, an ability and willingness to operate the state machinery. Now, this analysis and reasoning explains the country guidance in AB. Why that experienced tribunal used the words that it used in AB. So may I then take you to AB and address you very briefly on it. So AB is behind tab 8 of the bundle. So the country guidance is at page 221. Respectfully make 3 points about the first paragraph of the country guidance. The first submission relates to the words unless reasonably likely to be. These are the words that the Upper Tribunal effectively deleted. In my respectful submission, these words reflect the analysis in Haworth. The reason why that experienced tribunal made the point was that if one omits those words completely, then that would elevate the standard of protection to a guaranteed immunity or complete protection, unless reasonably likely to be admitted, are the words that reflect the Haworth standard. The second point, my lord, is that even if one crosses that point, and even if the fact finder concludes that a person would not be admitted into witness protection program, that does not mean that that person is a refugee. The second point that I make is about the word normally, and may I respectfully ask my lords, my lady, to take a note of word normally. The tribunal was at pains to, in my submission, to emphasize that even where a person is not admitted into witness protection program, that does not by default mean that that person is at risk. That means that in general, normally, there would be no effective protection. The third point is the concluding words of that sentence. Receive effective protection in his home area. The tribunal is not saying that where there is a person who is not admitted into witness protection program, there would be at risk in Jamaica. They are saying that there would be a risk in his hometown, in his home area. And that point is then picked in the second paragraph, that whether such a person, this is a person who is not admitted into witness protection program, whether that person would achieve protection by relocating depends on the particular circumstances. But the evidence does not support the view that internal relocation is unsafe or unreasonable option in Jamaica in general. So if you have a gangster in Kingston, that does not mean that the gangster will have intent, ability, capacity to track you in a different corner of Jamaica. But it is necessary, the tribunal says, to make that assessment. If you look at the body of the decision, if you go to page 227, you'll see that the tribunal relied on Howarth and the summary of the relevant principles in the judgment of this court in Bagna Divisius, where Howarth was considered. And you'll see right at the end of page 227, sufficiency of state protection means willingness and ability on part of the receiving state to provide through its legal system a reasonable level of protection from ill treatment. So the tribunal had that standard in mind, and that then explains in my submission why it said what it said at page 225. So page 225, you will see a heading just above the heading protection against criminal gangs. You'll see that the tribunal rejects the evidence, the submission that there is general insufficiency of state protection in Jamaica. So page 225.
225.
Yes, paragraph 150. So there is page 225, paragraph 150. So there is the finding is
255, not 225.
255.
my apologies, 255. My
I'm
fault.
normally terrible with numbers.
My fault.
Paragraph 150.
So this is the finding that is reflected in the first sentence of the country guidance, that there is in general sufficiency of state protection. So in general, Jamaica is able and willing to protect its citizens. The attention is then drawn in relation to criminal gangs. And the tribunal considers whether there is a risk despite the general sufficiency of protection. And then if you look at paragraph 153, last three sentences, fifth last line is the conclusion. In our view, this evidence shows that Jamaican state has both the willingness and ability to protect in cases where persons will be admitted into their witness protection program. This program has shortcomings, but record is extremely impressive. So the program is built for protection of people who are at risk from gangs. Well, that is the whole point of the program, to protect those who have given evidence, who were witnesses previously. The program is was designed to protect people like CP's mother and indeed CP, and the record is extremely impressive. So the court therefore should proceed in my submission on the basis that this is an extremely impressive program. And if CP returns there, one can have confidence that protection would be provided.
If he goes into the program.
No,
If he goes into the program.
well, yes, I mean, the court should, in my submission, proceed on the.
That's what 155 is all about. I mean, leaving aside the issue, which is a real issue before, or at least one of the issues before us, where the burden of proof lies, what 155 is saying in clear terms is there's a protection gap. And if you're not in the program, they accept Mr. Sober's about strongly points to not being able to secure protection from the authorities through the range of non-protective functions carried out by the authorities, unless they can internally relocate without being at real risk of detection by the gangs. So what that's saying is perfectly clear that unless there's relocation without detection, there is a protection gap. So that if you're not in the program, you're at risk.
In my respectful submission, this is. I seek to persuade you that this is not what they are actually saying. They are not,
saying.
no, they are not saying in my submission that if you are at risk from a criminal gang and if you do not go into the witness protection program, you will be at risk. I accept that they are saying that there is a protection gap, but that does not mean that every single person will be at risk. I mean, it really depends on that person's circumstances. Is it possible if the risk, for example, is in Kingston, is it not possible for that person to move to a different area? If the person does not go into witness protection program, are there any other steps the person can?
Yes, provided that the gangs in question don't find out that he's relocating.
Yeah, so this, you'll see this in the context. Well, I'm not, can I say this, that the word normally is of course used in the actual country guidance, and that's all that I need. Just finally, paragraph 155. Well, this reflects the controversial country guidance, controversial part of the country guidance, that the tribunal recognized that apart from the safety net of this program, that is a safety net, there does appear to be a protection gap for persons targeted by gangs who are not reasonably likely to be admitted into this program. This, in my respective submission, is an accurate statement of law. Who are not reasonably likely to be admitted into the program, then the evidence strongly points to them not being able to secure protection from the authorities to the range of normal protective functions carried out by the authorities. But still not in every case, unless they can internally relocate without there being a risk from their persecutors.
Well, the nub of the point is the difference between that language, not reasonably likely to be admitted, and what was said in 153. The evidence shows Jamaican state has the willingness and ability to protect in cases where persons will be admitted, and the protection afforded as a matter of fact depends on whether they are or are not in the programme, not on some degree of likelihood, whether it's possible, probable, or anything else, about whether they get into it or not.
So yeah,
that's the point against you, essentially.
Yeah. So the answer to that point, in my respective submission, is that if the real test is admission into the program, then that elevates the test beyond the Horvath standard.
No, because what is being said is if you're in the program, then the Horvath standard is met. It still won't be a guarantee, but the Horvath standard is met. If you're not in the program, there is a protection gap. And what Mr. Sober's evidence is that, subject to relocation, then there isn't a sufficiency of protection provided by the state. And that's essentially what the country guidance is saying on the evidence, isn't it?
The country guidance in my submission is saying that in general, Jamaica is safe. In general, state is able and willing to provide protection.
Well, we're not concerned with that because this is criminal gangs country guidance. It's dealt with the position by way of background running up to paragraph 150, and that's making the point that generally there's a sufficiency, but we're giving guidance on those, and the cohort that it's looking at are those identified in paragraph 151, which you, if I may say so, correctly identify, can only be those who face a real risk of being targeted by criminal gangs. And you say that's a factual question that has to be addressed before you get into this. And I entirely understand that point. But once you are within the cohort of those who face a real risk of being targeted by criminal gangs, what's being said here about the Horvath standard of protection is you get it if you're in the witness protection program, you don't get it if you're outside it.
Yes. So,
and that's not a question of whether you're reasonably likely to be in the program or not. You get the standard if you're in the program, you don't get the Horvath standard if you're outside the program. I think that's the nub of the point that's put against you.
yes, but
What is there in this that suggests that they're saying something different.
Well, I have no difficulty with that analysis, but the question, of course, as the court knows, is about admission into the program here. If he's admitted, then there isn't a problem. The question is whether he would be admitted.
Yeah.
Whether he would be admitted.
Where being admitted makes the critical difference about whether there will be a Horvath standard of protection or not.
So whether he would be admitted is a question that, in my respectful submission, ought to be answered by reference to Horvath standard. If there is a witness protection program and a functional system in Jamaica, then and that is the reason why I was seeking to emphasize the fact that there is in general protection in Jamaica. Then the fact finder, the court should proceed on the basis that there is willingness and ability to protect people like CP.
We seem to be going around in circles with respect to this debate. You seem in that submission to be suggesting that there is some sort of halfway house where if you're not in the programme, you still get sufficiency of protection from the Jamaican authorities. That seems to me to be flatly contrary to what's said in 155.
No,
and there's no evidence for it.
So, Lord, if CP returns to Jamaica, Jamaica will decide whether to admit CP into witness program or not.
Well, yes, but what the Jamaican authorities have said, based on the most recent threat assessment, the probability of harm against the family in Jamaica is high. And I think you accept that that reference to family must include CP himself. So they've obviously made a threat assessment in accordance with their own information about, for example, gangs in Jamaica. But there is still a high risk to the family. So that it seems to me that that means that unless he's in the witness protection program, he's at serious risk.
The difficulty then, again, it takes me back to the point that I made earlier by reference to paragraph 37, is that he would not take steps while he's in the UK to seek admission into the witness protection program. And therefore, the test in my submission is whether it is possible, whether there is a real possibility of him getting protection. If it's a matter...
Sorry, the test is whether there's a real possibility of him getting protection.
Yes, the test is whether it is reasonably likely that he would be admitted to witness protection program.
That's quite different from whether there's a real possibility. It's the case against you.
No, the submission is that the test is whether, for the purposes of this.
Well, I see. You say it's sufficient if there is a real possibility of him getting on the programme.
Yes.
Yes, I see. Sorry.
If you omit the words reasonable likelihood, a reasonable possibility, then in my submission, you have that submission that would be inconsistent with the Horvath approach. Now, what is the status of this country guidance? Of course, this court will decide what it actually means, whether the words unless reasonably likely to be admitted or to be omitted, as the Upper Tribunal said. That is a question of law for the court. One practical, one issue that is raised in the grounds, as I outlined earlier, is that how is it that the Upper Tribunal should take, what approach the Upper Tribunal should take if the Upper Tribunal concludes that a country guidance decision misstates the law. Now, the country guidance decisions have a special status. In the authorities bundle behind tab 1, you have section 107 of the Nationality, Immigration and Asylum Act 2002. And you will see that the statute provides that that the practice directions may require a particular decision to be treated as authoritative in respect of a particular matter. The purpose of that statutory provision is to ensure consistency. It wouldn't be possible for the tribunals to start looking at country evidence in every single case separately. The idea is that in one country guidance case, the Upper Tribunal would sit and give some country guidance. The practice directions issued pursuant to this provision are behind tab 3. And it's paragraph 10 that is relevant. Paragraph 10 says that a reported decision of the Upper Tribunal bearing the letters CG shall be treated as an authoritative finding on the country guidance identified in the decision unless it has been expressly superseded or replaced by another CG decision or is inconsistent with other authority that is binding. This is the judgment of this court. It should be treated as authoritative. Now, that is for the reasons of consistency. Assume, my lords, my lady, that AB misstates the law. The Upper Tribunal
Because
has...
it's inconsistent with the law, which is one of the circumstances which is identified from when you can depart from it.
Inconsistent with a binding authority.
Yes. Which is all the authority from Chahill onwards about what the relevant test is in Article 3 cases.
Yes.
Real risk, reasonable likelihood, 10%, all those cases.
There must have. I mean, it doesn't actually say wrong in law, but I mean, must have in mind when it says inconsistent with other authority that's binding on the tribunal. One of the circumstances will be, for example, decisions of the Court of Appeal or the Supreme Court of the House of Lords, which are binding on the tribunal, and which the particular tribunal in the country guidance case is misinterpreted.
Yeah. So the point, it's a very short point. It matters not to the outcome of the appeal. If there is an error in the country guidance, and if you look at the next paragraph, you'll see that the country guidance decisions are reported, they are on the tribunal's website, they are referred in country information or the policy that I've taken you to. This is paragraph 10.2. So if the Upper Tribunal takes the view that a country guidance case misstates the law, and if the Upper Tribunal simply makes a decision in that case to correct it, no one would know about it apart from the immediate parties to that case. The CPIN document will remain in place. All other judges would still take the view that the country guidance case reflects the law accurately, and there would be a risk, in my respective submission, of inconsistent decision-making. So the solution...
I don't understand that. Surely, when one's looking at country guidance, you look at the body of Upper Tribunal jurisprudence on the question. You'd look at both decisions, wouldn't you?
There are, I may have a number somewhere, there are thousands of decisions that the Upper Tribunal promulgates every year. Yes. It's just not possible. If a decision is not a sort of reported decision, it's not possible for a person to sort of track the jurisprudence. And unreported decisions are not citable decisions as such in other proceedings.
For where this point goes, I mean, paragraph 10.1 seems to expressly contemplate that the country guidance case is to be taken as effectively binding on subsequent decisions of the upper tribunal, unless they're inconsistent with authority that's otherwise binding on the tribunal, which would mean a decision of this court or the Supreme Court. So that's expressly recognising that an upper tribunal, such as in this case, present case, would be entitled to say the upper tribunal in AB misstated the relevant legal principle. Now, whether or not the decision of the upper tribunal in the present case was reported, and I don't think it was it? I mean, I think it's not on Bailey, for example. But I don't think it is anyway.
My lord, the decision would be on Bailey for sure, the upper tribunal's decision, but not as a sort of reported decision.
No.
And
But I mean,
so
far as the position now is concerned, if this court decides
that's it. Yeah.
that the law is misstated in AB, well, that's going to be binding on every upper tribunal.
Absolutely. Can I just show you, given the question that you've asked, just one authority that deals with that question as to the circumstances in which a tribunal should depart from a country guidance decision. Yeah. So that is tab 9 of the bundle CG. So, SG Iraq, the judgment of this court in SG Iraq. And this is where this court considered the practice direction and the relevant scheme and statutory provisions underpinning the concept of country guidance decisions. And the conclusion that is reached as to the effect is at paragraph 47, which is page 279. There is, as well as desirability for consistency, the decision makers and tribunal judges are required to take country guidance determinations into account and to follow them.
Well, that's
unless
I think all the reasons that precede that are all about because they raise an evidential presumption. They do a deep dive into all the evidence which is not expected to be available to subsequent tribunals, and even in those circumstances, they produce a presumption of fact, as I understand it. They don't actually bind subsequent upper tribunals, but what is being said here is upper tribunals should follow their findings of fact, unless there are very strong grounds supported by cogent evidence for not doing so. But
the way that test, I'm sorry.
So, yeah.
The way that test is expressed suggests that what the Court of Appeal had in mind in this case was the factual precedent set by a country guidance decision, and nothing to do with errors of law that may or may not be lurking in the text of the country guidance decision.
It's all to do with the facts.
Yeah.
I mean, it's perfectly understandable that what they're saying is if you've got a country guidance as to the factual position on the ground in Jamaica, then so far as the factual position on the ground in Jamaica is concerned, subsequent tribunals should follow that country guidance and apply it, unless there are cogent reasons for not doing so. And one obvious cogent reason for not following on the facts is if there is evidence before the second tribunal to the effect that the position has materially changed since the first tribunal, in which case the second tribunal may have to consider giving fresh country guidance. But none of this has got anything to do with whether or not there's been an error of law.
Lord, the point, of course, does not affect the outcome.
No, but you're wanting us to give guidance for the future.
I do understand.
If the point does not affect the outcome.
No.
But so the Secretary of State has published a policy document that cites what the Upper Tribunal considers is erroneous statement of law.
Yeah.
Now that policy is then followed by decision makers and judges.
Well, it'll have to be changed, won't it, in the light of the subsequent decision?
Yes,
and the Secretary of State will be aware of the subsequent decision, and with its duty of candour, it ought to draw it to the attention of anybody in a future case. So the fact that it's not publicly reported it's not in practice going to cause a difficulty, is it?
The-
Everybody's going to know about it because it'd be the duty of the Secretary of State to draw it to people's attention.
Yes, but the point,
I mean, at least what you say in writing, and I think it's maybe the point you're still making, is that what should have happened is there should have been a fresh country guidance.
yes,
But another way of looking at it is to say, well, okay, this upper tribunal did what it did, and it said there'd been an error of law. That then comes to this court, and this court then gives an authoritative judgment as to what the law is.
that is
And
absolutely,
that's just. I mean, one way, frankly, Mr. Malik, it might prove ultimately to have been less expensive so far as the public purse is concerned to have gone this route rather than gone down another country guidance route.
well,
Given the SIP-in
Yes.
is saying there hasn't really been a material change of circumstances.
unfortunately, my lord, that did not happen.
No.
Ultimately, because of what had happened, the Upper Tribunal ultimately convened a country guidance panel because there was, on any view,
Yeah.
at least a conflict of authority or a tension between a country guidance decision and the Upper Tribunal's decision in this case.
Saying that's not right, it was convened ages before, it's simply.
Okay, now, I'm not suggesting that the country guidance panel was convened because of that reason.
Is this the?
This is EP you're talking
This
about.
is EP, so I'm not suggesting that the country guidance panel was convened for that reason. But the Upper Tribunal took the view that, well, this was the right time to consider country guidance.
But the position is
But
that EP is stayed
Yes, and
by consent until this court
this court, yes,
delivers judgment.
indeed. But what I do know, of course, is that this was one of the key controversial issues in the country guidance case, as to whether what is said in AB is accurate or whether what this tribunal has said is correct.
But
And-
you tell us that before the, are you actually instructed in EP?
I'm not, no, I'm not.
But whoever was acting for the Secretary of State in EP proposed a further amendment, as it were, to the first paragraph of the head note, which we've got in paragraph 3 of your
Yes,
supplementary skeleton. And Mr. Chirico says I think in paragraph 4 of his, that that is entirely consistent with CP's position and he supports it.
so my lord,
What we're dealing with really, if that's right, is what's the right form of words?
Lord, if you look at paragraph 4 of my supplementary skeleton argument, so the submission, my lord, is that if you take the view, if you reject the submission that I've made, if you take the view that formulation in AB is wrong, I seek to persuade you that it's not wrong, but if you take
It's
the
very
view,
difficult. I mean, there seems to be a slight inconsistency here, because what's being said, if you're right, is that the Secretary of State has positively put forward an alternative wording in EP, presumably on the basis that the Secretary of State has formed the view that AB is not
no,
accurate.
no, that's my fault. I apologize. So this, if the
So it's
conclusion,
all on a contingent basis, is it, that in EP, the Secretary of State is saying there's nothing wrong with AB at all, but if you think there is something wrong, then this is what you should do.
so.
Is that?
Yeah. So in AB, I mean, of course, I wasn't there, but I've spoken to
No,
counsel and I've taken instructions. The Secretary of State's position in broad terms is that, well, AB stands. The country guidance given in AB is still effective despite all the changes, etc. So that is the Secretary of State's broad position. The tribunal issued directions to the parties saying that, well, we want to, we are effectively sort of in broad terms that we are troubled by the formulation of law in the head note of AB and invited submissions. The submission that I make is that if you take the view that AB is wrong, then the solution is this formulation. It is not the formulation that the Upper Tribunal adopted in this case by simply adopting the words reasonable reasonably likely to
Striking out those words.
strike
Yeah.
out those words. So if there is a problem, then in my submission, this is the solution. Now,
Sorry, just before we leave your point on what should the Upper Tribunal do, can I just ask you to look at the reasons at page 48 of the core bundle behind tab 6?
yes, so the Upper Tribunal.
The Upper Tribunal's reasons for refusing permission to appeal. And I just wanted what the Upper Tribunal said about this is at subparagraph 5 on page 48. And I just wondered what, if anything, you said that was wrong about the way they'd addressed it.
Sorry, paragraph 5.
Paragraph 5, starting first, paragraph 3 to 4, the grounds of appeal mischaracterised the nature of country guidance case law. And you might want to take a moment, we'll all take a moment just to remind ourselves of what the Upper Tribunal there said.
Yeah, so that is not controversial. So the Upper Tribunal's decision are not are certainly not binding authority on the Upper Tribunal. That wasn't the point that I was seeking to make. The point was essentially a practicality and consistency. That consistency, the principle of consistency, which underpins the idea of reporting decision, means that if there is a problem with a country guidance decision, then that problem should be addressed by a country guidance panel.
Yeah, but this answers that. I just want to say what's wrong about it. They make the point that, as the Upper Tribunal had already said in Roba, the purpose of country guidance is an exception to the principle that findings of fact will not in general bind a subsequent tribunal. It's intended to ensure consistency of decision making in cases where the same factual issues arise. 12.2 of the relevant practice decision makes clear country guidance determinations to be treated as an authoritative finding on the evidence. It operates as a presumption of fact, applicable in other cases raising similar factual issues, not however binding on the Upper Tribunal even as to factual issues, and it's certainly not binding authority on points of law, where a legal interpretation in country guidance is at odds with binding legal authority of the senior courts. The Upper Tribunal must give effect to the latter. Now, which bit of that's wrong?
It's nothing wrong with that. So the Upper Tribunal will give effect to the binding authority, but how is it that the Upper Tribunal should go about making that decision? Whether one or two judges of the Upper Tribunal do that by a decision that isn't a reported decision, or the Upper Tribunal does that by way of country guidance.
But that wouldn't be addressing the problem.
No.
A fresh country guidance case would look at all the evidence afresh to see whether the factual findings in the previous country guidance aren't correct. If there's a new case from the Supreme Court that one can see means the way it's expressed as a matter of law in the country guidance is mistaken, but the facts doesn't affect the factual findings, what on earth is the purpose of having a newly constituted country guidance tribunal to look into all the facts again?
Yeah.
So isn't the last sentence of this right? What you've got to do is, if it's at odds with binding legal authority, then you must say so. And having a fresh country guidance decision won't be addressing itself to a legal development. It'll be looking at factual developments on the ground.
The country guidance panel deals both with law and with facts.
So does the Upper Tribunal generally. The Upper Tribunal generally, never mind country guidance, but on the law, any constitution of the Upper Tribunal has to give effect to the law. And if there are decisions of the Court of Appeal or the Supreme Court which are inconsistent with another Upper Tribunal decision, it has to follow the Court of Appeal and the Supreme Court.
But if a country guidance panel has considered an authority of the Supreme Court and this court, and has explained what that authority says, is it, again, doesn't it has no effect on the outcome of the appeal, but it has.
The argument here, as I understand it, is not that the Upper Tribunal and AB somehow misquoted the HOAF, for example, misquoted the authorities, or simply they misapplied them. Or that the paragraph 155 of their judgment is inconsistent with where the burden of proof lies under the authorities.
The authority that they had considered.
So why do you need to have a fresh country guidance panel?
So,
I mean, has there been just as a matter of you may not know the answer to this question, but I mean, in the light of the CPIN report, which I think the latest version of it is sometime in 24, this fresh country guidance panel in EP, has it received a whole load of fresh evidence factually about the ground position in Jamaica?
Yes.
So that may have some impact, or it may not, I suppose.
Yes, but of course I mean, one of the issues that they will deal with is what the test is, what AB actually says.
Yeah.
And they'll wait for the judgment of this court. Can I respectfully invite you to perhaps test the argument in this way that, well,
So we're pressing you on things.
if it is entirely apt for one upper tribunal or the first-tier tribunal to say that, well, Howard says something different, I'm going to omit those words from the upper tribunal's decision. A different constitution of the upper tribunal, the first-tier tribunal, may say, well, that is not correct. I will still follow AB. And that would then lead to inconsistent decisions. Hence, there is, in my submission, a system that where...
But they would still do that if you convened a new country guidance tribunal to make that decision, because any decision of the upper tribunal doesn't bind another upper tribunal on questions of law. It does have special status in relation to facts and evidence. It has no special status at all, does it, under the statutory instruments as to decisions of law?
It has. So the upper tribunal has a system that, I mean, I can bring further documents.
But you were showing us the statutory materials that deal with the status of country guidance cases. Was there anything in that that suggested that they have a special status in relation to determinations of law?
No. So there are.
So whatever the practice may be, they don't, as a matter of law, have any special status today, as opposed to other decisions of the upper tribunal.
So the upper tribunal has a system of reporting decisions. There are guidance documents, practice directions as to how cases are selected for reporting.
Right.
There is a judicial reporting committee that picks cases for reporting. And the guidance is that if there is a reported decision, then that decision is to be followed even on legal issues, unless and failure to sort of follow them would amount to an error of law. That means that a decision is not binding in a sense that would not be binding in the same way as a judgment of this court. But the practice, the system is established essentially to ensure consistency, that if a point of law is decided in a reported decision, then other decision makers would follow that.
So it might follow then that the decision of the upper tribunal in this case, which, as I understand, it wasn't a reported decision.
Should have been.
Well, but if it wasn't a reported decision, other constitutions of the upper tribunal are not bound to follow it. Is that right?
That is right, yes.
Yeah. Okay.
And well,
That slightly undercuts your argument, doesn't it?
Yeah. No, I mean, I'm not. With this fact,
I myself have some difficulty with the idea that upper tribunals are bound to follow some decisions of other upper tribunals merely because of the administrative practices of what judgments are or aren't reported, or what some committee decides should or should not be reported. That doesn't sound to me a very sound constitutional basis for what binds an upper tribunal, and it strikes me as quite surprising that that should be so, as between tribunals of coordinate jurisdiction.
Lord, may I just make it absolutely clear that I have not made a submission. If I have, then I apologize. I'm not saying that a decision of the upper tribunal, whether reported or not, is binding on another upper tribunal. It is not. It is not binding for sure, but the system of reporting decision is set up to ensure consistency, that if there is one reported decision, then other judges are expected to follow it. But it happens from time to time that the upper tribunal would disagree with the reported decision and would say that, well, it's wrong, and decline to follow it, as has happened here. If the decision in AB's misstates law, then as I said, then the guidance, Secretary of State's guidance misstates law, and the proper way in my submission to deal with it is not by way of one single decision of the upper tribunal that no one would know about apart from immediate parties, but by way of a reported decision. But it matters not, Lord.
We've taken longer on this than perhaps we needed to, but you were keen for us to give some guidance about what upper tribunals should do rather than what we should do. And so that's why, that's why we've been exploring it.
Yeah,
but as you say, it may not ultimately matter.
If this court says that, well, AB misstates law, then that, of course, would be binding. Everyone would know that is what the law is, and it would be followed. So may I then just take you to the upper tribunal's decision then?
Yeah.
So the upper tribunal's decision. Page 53 of the bundle.
Yeah.
Well, ground one, Lord, is that the upper tribunal erred in law as to AB. So paragraph 26 is the conclusion. The upper tribunal simply omitted the words reasonably likely to be. And for all the reasons that I have given, that is wrong. So if you accept the submissions that I've made so far, you will accept ground one. If you do not accept those submissions, you will reject ground one. So that really is ground one.
Yep.
Ground two. That relates to the upper tribunal's remade decision. And may I respectfully take you back to AB, the parts of AB that are relevant to the second ground. And will then address you on the upper tribunal's reasoning. So AB, again, behind tab 8 of the bundle. And when I made my submissions earlier, my lords, my lady, I emphasized on the word normally in the country guidance and in his home area. If you go to page 255, sorry, you have seen 256. So you have seen the earlier part of AB. 256, there is a heading internal relocation. And under that heading, the tribunal considers the question of whether internal relocation would be viable. If you go to page 258 and see paragraph 164, so, my lord, for the purposes of this argument, I will assume that you will reject ground one, and you will conclude that this is a person who would not be admitted to the witness protection program. This is an alternative ground. What, however, would be the position of a person who would not be admitted to witness protection program? This case, the tribunal did not say that if you answer that question in yes, the appeal allows. The tribunal says that then you consider the question of whether it is reasonably likely that they will be traced and targeted in their new place of residence. We do not consider that except in high-profile cases, such persons would face a real risk of being targeted by gangs, but each case will turn on its own facts. And then 166, the tribunal was careful to re-emphasize the point, because it is an important point, that you don't get protection simply because you're not admitted into the program. We would emphasize at this point that what we have just, so in order to, this is really the second part of that paragraph. In order to show that such a threat exists, it will not be suffice to show that a criminal gang dislikes an individual, or even that it has made threats of violence. It has to be shown that the gang has real intent to inflict the threatened person with harm and carry out threats. So this is what is said about the alternative. So the question for the fact finder, if the fact finder concludes that a person would not be admitted onto the program, is whether the gang has an intent to inflict serious harm, whether
This is paragraph 50 of your skeleton, essentially.
paragraph 50, yes.
Those are the essential points.
Yes,
Yeah.
whether internal relocation would be unreasonable, post-rated, etc. Now, the Upper Tribunal at the hearing, as the court knows, after hearing submissions, indicated to the parties that they intend to set aside the decision. This is page in the core bundle, page 58. So page 58, paragraph 27, the upper tribunals at the end of that paragraph finds that there is a real risk that the appellant would not be able to access the program. And that is the finding. They then said that there would be, the Upper Tribunal would set aside the decision, this is paragraph 33, and would remake the decision because it was common ground. They said that the appellant would not be admitted onto the witness protection program, or there is a real risk that he would not be. And that is the end of the decision. They said that no one opposed the proposal. The presenting officer declined the invitation to make any further submissions, and they allowed the appeal on that basis. Now, there is no engagement in my respectful submission with the points that I have identified at paragraph 50 of my skeleton, the points that the Secretary of State made in her decision that stood as her case, and in her skeleton argument that I showed you earlier this morning.
Well, things have moved on a bit since then, because the letter from the Jamaican ministry saying that the threat to him was high and that he was eligible for the programme was pretty powerful evidence. It may not be very surprising, therefore, that the senior presenting officer didn't feel able to advance any other arguments of the kind that you're now suggesting should have been made, because they were contained in the decision of the Secretary of State, for example.
Yeah, because the letter doesn't refer to a threat in his home area. It says the probability of harm against the family in Jamaica is high. High likelihood of psychological trauma if he returns to Jamaica. So
Yes.
there isn't any suggestion that there might be a bit of Jamaica that's safe.
In the letter from the Jamaican authorities,
Yeah. Which is it's set out in paragraph 18 of the FTT's decision,
Yes.
page 79. It's
Yeah.
elsewhere as well.
so Milady is right. So this is what the letter said.
Yeah.
The country guidance, in my respective submission, points to a different conclusion. The country guidance says that a person who is targeted by gangs.
The country
Yes,
guidance
but-
says what the country guidance says in generic terms about the general position in relation to people who are targeted by gangs. The letter from the ministry is specifically related to this appellant and his family, or this respondent and his family. And the answer is based on the most recent threat assessment, which is obviously more recent than the country guidance in 2007. The probability of harm against the family in Jamaica is high, capital letters.
Yes. So this is what
That's clearly what, I mean, that's the point that Mr. Lewis made at paragraph 30 of the judgment there. I think they're citing the submission rather than making a finding. But they then make a finding at 33. And they say in terms it was common ground, there was a real risk he would not be admitted. And that nobody made any further submissions. And then my lord was just putting to you, it's not surprising given what the letter from the ministry said.
So letter from the ministry, of course, points to the conclusion that there would be at risk. But in my suspicion, the obligation on the Upper Tribunal was to engage with the issue.
Where's the evidence from the Secretary of State that he could have been relocated somewhere?
Well, in the decision and in the CPIN document that I've shown you.
No.
Yeah.
Well, this particular respondent could have been relocated safely somewhere.
To avoid, and
avoid-
wouldn't have been
to avoid the high risk.
detected by the gangs.
If
I mean,
he didn't get into
isn't that question subsumed in the ministry's view that the risk to him in Jamaica is high? I think that's the point my lady was making to you.
So acceptable. That is the evidence, strong evidence that supports CP's position. The question is whether that is determinative in the sense that there is no room for a different outcome.
Well, the question, I think the question is whether it would be right in circumstances in which the senior presenting officer didn't see fit to advance any argument that any of these matters were in the circumstances of this case live issues, whether it would be right to say that the Upper Tribunal made an error in taking that at face value and remaking the decision in accordance with the stance which the parties took in front of it. Isn't that the first question?
Yes, Lord, of course, you have heard my submissions. If you retire and come back and say to me that, well, our provisional view is that we want to dismiss your appeal, do you want to make any further submissions? And if I say no, there isn't anything further that I want to submit, that does not mean that I abandon everything that has been said previously.
No, but
my lord's not what my lord's putting to you is that it's very difficult to say that they made an error of law if they took at face value the fact they didn't want to make any more submissions.
and
And wasn't objecting to the disposal.
I mean, this was an inquiry specifically about what should happen now, having found that there was a material error of law on ground one, and they say, well, our provisional view is that we can redecide it on the facts, and that given its common ground that there was a real risk the appellant wouldn't be admitted into the witness protection programme, then that would mean that the appeal would fall to be allowed. Now, Mr. Tufan, do you want to say anything about that? Do you disagree with that, or do you want to make some further submissions about whether that is the consequence of our conclusion? Answer from Mr. Tufan, no.
But also, what the Upper Tribunal say in paragraph 33 is that they indicated to the parties that the Upper Tribunal could redecide the appeal on the facts as found below. So that rather squashes the idea that they were obliged to consider the points that were taken in the refusal letter, because what they were saying to the parties is, we can do it on the basis of what the FTT found.
So, and if you look at the first-tier tribunal's decision, which you have, the first-tier tribunal made no findings on the alternative questions.
No, I think that's probably
That's the point, isn't it? If the FTT didn't make any findings that he could safely move somewhere else, and you've got the letter, how can it be a wrong in law for the Upper Tribunal to say, well, he's at risk in Jamaica, at high risk?
No, the first-tier tribunal did not make the finding about internal relocation because the first-tier tribunal dismissed the appeal on the primary reason of sufficiency of protection. So there was no need for it to engage with the alternative points.
No, I quite understand that if what Mr. Tufan had done is to say, wait a moment, it doesn't necessarily follow. We haven't got any findings on ability to relocate. We haven't got any findings, despite the letter, that he would be targeted by gangs. You've got to send that back for some further findings. Well, then the Upper Tribunal would have had to engage with that and decide whether there were sufficient findings on that or whether it ought to be sent back. But he didn't.
No,
And speaking entirely for myself, that seems to me a fairly realistic acceptance of the evidence that was available by that stage, which was different from that on which the Secretary of State made her decision initially.
Yeah, so I cannot hide from the fact that no submissions were made.
And both the First-tier Tribunal and the Upper Tribunal, as it happens, quote the letter from the Jamaican Ministry in full.
Yes, the letter that
So they've obviously both the First-tier Tribunal and the Upper Tribunal had well in mind the point that my lady put to you, that the probability of harm against the family in Jamaica.
yes.
So it's not saying, well, in Kingston, in Montego Bay, it's saying in Jamaica.
But you read that in my special submission in the context of the question that is asked. So the question wasn't about internal relocation. The question wasn't whether it is possible for.
The Secretary of State could have asked a specific question. What about internal relocation? But she didn't.
Well, she didn't. Yes, and
It could have gone back to the ministry since and asked the question. What about internal relocation?
yes. So
That evidence before the Upper Tribunal at the last, or tried to put it before the Upper Tribunal at the last time.
well, these are all with respect entirely cogent, valid.
The
valid
problem
points.
you've got is that you ask us to bear it in mind, but there's no evidence. And the burden was really on you. If there was going to be evidence that some form of internal relocation was appropriate for this particular respondent or appellant.
Lord, this court has said that there's no question of being burdened on any party in an exercise of this sort.
Not burden, I'm putting it correctly, but if there was going to be evidence about relocation, it would have come from the Secretary of State.
So the fact finder conducts a holistic assessment of all the circumstances and decide whether internal relocation is viable or not. The letter, my lord, that you have in front of you points to a conclusion that internal relocation is not viable. But there is other evidence to which I've taken you to in the policy documents, in the Secretary of State's decision in AB, which points to a different conclusion.
Yes, but that's
Not for-
generic.
That's generic, that's not for this.
And this is a specific
individual.
threat assessment.
I mean, Mr.
about-
Tufan will have known, sorry to interrupt,
Sorry.
will have known all the background material. He'd had to move however many times he'd had to move when he was in the witness protection program to a whole lot of different locations. There was the letter saying that the threat was to him in Jamaica generally. And why shouldn't we take at face value the fact that he assessed the position to be that the evidence in this particular case meant that relocation wasn't a runner?
Well, because he, well, if
I mean, he must have taken that view, mustn't he, in order to have responded in the way that's recorded?
well, earlier in the Upper Tribunal's decision, you'll see Mr. Tufan making submissions that the tribunal should not depart from AB.
Yes.
And I accept, of course, that there is. I mean, he made no submissions. The way I seek to put my case is that, well, he certainly made no submissions, but the country guidance tells us that if a person is not admitted into a witness protection program, then normally there wouldn't be sufficiency of protection, subject to ground one. But where there is such a case, the decision maker should consider the question of internal relocation and other matters. And the Upper Tribunal should have conducted that exercise.
Are you saying the Upper Tribunal erred in law in, as it appears to have done, relying on the individualised threat assessment in the letter?
No, the Upper Tribunal erred in not considering that question, the question of internal relocation. If the Upper Tribunal had said, for instance, that well, we take into account the letter from Jamaican authorities, we have considered the background evidence, the reasons the Secretary of State gave in her decision, and for X, Y, and Z reasons, we conclude that internal relocation is not a viable alternative, they would then be following the country guidance.
They could have spelt it out more clearly, I agree. But the fact is that they said, as we've already pointed out to you, they said that they could decide the appeal on the facts as found below. And one of the facts found below was what the Jamaican ministry has said about the risk of harm. So it's really
Well,
subsumed, as my lord put to you, it's all subsumed within that, isn't it?
Well, I mean, of
I mean,
course,
it doesn't spell out relocation isn't a runner because of what the Jamaican ministry has said. That's effectively what they're deciding. Which is probably why they dealt with it so shortly, because they didn't think there was anything in the, and it wasn't raised on the appeal as such, so far as I can tell.
it was certainly raised on appeal to the First-tier Tribunal. That was,
Yeah, on the First-tier Tribunal,
Yes.
but not before the Upper Tribunal.
yes, the appeal before the Upper Tribunal was CP's appeal from the First-tier
I know,
Tribunal's decision.
And the fact of the matter is that for whatever reason, the Secretary of State didn't instruct counsel and didn't file a skeleton argument, even though there was an order that she should. She didn't file a skeleton argument.
No.
The Upper Tribunal decided the case, and now you come before this court and say they made an error of law in not deciding a point which wasn't argued before them. That's effectively what it amounts to.
It does. Can I then?
I'm sorry, Mr.
It does.
You're probably glad I retired some time ago.
Yeah.
Yes, it does. Now, how is it that this court should approach then the submission, a submission that is not made by the Secretary of State at the Upper Tribunal? The authority that may assist you on that is behind tab 18 of the authorities bundle.
OSB.
Yes, OSB. So this is a case where an Article 3 appeal is allowed. and a point that is material wasn't made by the Secretary of State at the Upper Tribunal. And the point was made for the first time at this court, and the applicant in that case objected to that, saying that, well, this point should have been raised at the tribunal. If you go to page 559, if you look at paragraph 28, and if you look at the last three sentences, so the new point was the intense suffering point, that the tribunal made no finding as to whether there would be intense suffering on return. That was part of, so the point was that there were insufficient findings made by the tribunal. So the intense suffering point was a new point that was not raised before the Upper Tribunal. The Secretary of State did not say that, well, allow the appeal on that basis. The guiding principles are in Singh and Das. And these are the principles, my lords, my lady, that you will apply in deciding whether to permit me to make the point. This is a point that was made by the Secretary of State at the first instance before the First-tier Tribunal. It would not have affected the conduct of the trial before the First-tier Tribunal. The Secretary of State made the point, the appellant had used evidence. There is adequate notice, and one, and then you'll see a point about protecting costs. So although the Secretary of State was successful in that appeal, the court decided to make no cost order in the Secretary of State's favor.
What about the second point? Is it your submission that the matter should have been and should now be remitted to the First-tier Tribunal to reconsider the question afresh?
Yes.
With such new evidence as either side wish to advance?
Yes, so
so that it is a point which would necessitate new evidence.
Well, Lord, it is of course open to the parties to adduce new evidence, but here the Secretary of State made the point in the decision, in the appeal proceedings. The appellant adduced evidence addressing all issues, including that issue. There are no findings on that particular question. So in my submission, if there is a remittal, then the fact finder will evaluate all the evidence and make a decision. That would not sort of necessitate new evidence in the sense that the parties would not be obliged to provide new evidence, but it would be open to them to do so. The authority that is cited against me is the judgment of my Lady Justice Elisabeth Laing in AL. I will not take you to that authority now. My Lady, in that case, essentially summarized the new procedure that applies at the First-tier Tribunal. The parties are required to identify issues, proactively assist the tribunal in making the decision. No one, Lady, with respect would dispute that. But here I say that the point was properly identified by the Secretary of State in the decision in her skeleton argument. And when Mr. Tufan said that he was not making any further submissions, further is the word that the Upper Tribunal used, that did not mean that he was abandoning the points that were made earlier. And there was hence an obligation on the tribunal to deal with them. Lords, my Lady, I'm very grateful. So unless there are any questions, these are my submissions. I'm very grateful for your patience.
No, I don't know. Thank you.
Thank you very much. Perhaps we'll just rise for a moment to see where we are.
Court rise in favour.
So we'll have a spot. Yeah, they're coming back. Oh, sorry. Yeah, we are. Tell you outside. We think we're close to time.
Court rise in favour.
Mr. Jericho, we're going to adjourn for lunch and then we'll have you start at 2 o'clock, please.
Court rise in favour.